So, we'll get started. So this was in January of 2022. And who was present in person? In-person appearance by Mathew Rosengart, Lisa McCurdy for Britney, Alex Weingarten for Jamie Spears, Geraldine, Wyle. Oh, no, that's Court Connect. So then former counsel for Jamie Spears, Geraldine, Wyle, Jeryll, Cohen were on the phone. Vivian, Thoreen was on the phone. Stanton, Stein, Ashley, Yeargan, former counsel for Jamie Spears. John Sable, temporary conservator. No, his counsel, Justin Gold, was on the phone. Sam Ingham, former counsel for Britney, was on the phone. David Nelson, Ronald Pearson, former court-appointed counsel for Britney Spears, was on the phone. Lauriann Wright, counsel for former temporary conservator of the person, Jodi Montgomery. In-person appearance, Lynn Spears' attorney was present, Yasha Bronshteyn. And then Gladson Jones, Lynn Swanson for Lynn Spears was on the phone. TriStar Management's attorney, Eric Adler, and Diana Feinstein were on the phone. Oh, Alex, I'm sorry. Yeah, this is a script from last month. I would totally start drinking now, except that I'm not able to do anything after that. And I need to go work out all of my... Alex is in Canada. Hi, Serona. Diana, not Diane Feinstein. That would be interesting. Okay. I'm just going to read through. If you haven't been here for one of my court reenactments, which is what I'm calling it, these are fun times. It's commentary. It's dramatic read-throughs. Am I an aspiring actress? No, I am not. I just get very heated when I talk about this stuff. My Peloton handle is Heather at the ESQ. Court says, good afternoon, everyone. I'm going to get everyone's appearances in just a moment. I have some preliminary matters that I need to address with the gallery so that we have a smooth proceeding. No phones, no laptops, or other electronic devices, including Apple Watches or any other smart watches. No picture taking or recording of the proceeding. If you want to take notes, pens and paper only. Please do not disrupt the hearing by gesturing, laughing, waving arms or hands, or otherwise creating a distraction. This adversely impacts my court reporter and my clerk. Please do not approach courtroom staff. Thank you. Okay, counsel, I'll get your appearances of counsel at the counsel table. Then I'll proceed to give to the parties appearing remotely. Then I want to give you some information about how I'd like to proceed today because there are quite a number of matters on the court's calendar. Counsel, I'll start with you. Mr. Weingarten says, good afternoon, Your Honor. Alex Weingarten, Wilkie, Farr, and Gallagher on behalf of James Spears. Court, thank you. Mr. Bronshteyn, good afternoon, Your Honor. Yasha Bronshteyn on behalf of Lynn. Rosengart says, Your Honor, Greenberg Traurig on behalf of Britney. McCurdy, also on behalf of Britney. Good afternoon, everybody. And at the counsel table, then I'm going to just go in order here for the parties on LA Court Connect. They all give their appearances as we just discussed. The court says, okay, Eric Adler, I've got you on the line as well. Mr. Adler says, good afternoon, Your Honor. Eric Adler on behalf of TriStar Management. Court says, thank you. Justin Gold, good afternoon, Your Honor. Justin Gold on behalf of former temporary conservator of the estate, John Sable. Thank you. Jeez, more appearances. Yada. Samuel Ingham, Lynn Swanson, Vivian Thoreen, Diana Feinstein. Lynn Spears was not present. Montgomery, Sable. I appreciate everyone's patience while I got all the parties and counsel's appearances. And what I wanted to talk with counsel about is that I kind of divided things into 3 stacks. One stack, and we'll be talking about all of this. One, I'm reading directly from the court transcript. One stack is really matters that we're probably going to dispose of or take care of today. One stack is matters that have been trailing along, and I kind of want to talk about them first to see kind of where they are going to be sitting in this whole situation, because we've been taking care of more exigent matters in the last few hearings, but these matters are trailing along, and I really don't want them to get lost in the shuffle in terms of Jeryll's off. And some of them were filed before Miss Spears had you, Mr. Weingarten, as counsel. I must have made a mistake, because it says before Miss Spears had you, Mr. Weingarten, as counsel. That's not her counsel, though. So I just want to, you know, get a sense of what's what with that. And then, of course, we have the newly filed petition that you filed, counsel, that's before the court. So I really want to start with the matters that have kind of been trailing along here. And then I also have a question or a concern about a couple of orders that I want to talk about as well. First of all, we've got calendar number 5007, and I'll tell you what that is. That's the petition that was filed by Mr. Ingham seeking fees for Loeb Loeb, who was court-appointed counsel for Miss Spears at an earlier time. And there have been no objections filed to this petition. It's just been sitting there. Okay, the other ones. The other petitions are the following. Mr. Ingham, as court-appointed counsel for Miss Spears before he was discharged, has 3 petitions for fees, and they're set out in different time frames. So one petition is for fees for October 2018 to September 2019. Another is for October 2019 to September 20. And the final is October 2020 to February 2021. And there are calendar numbers 5008, 9, and 11. There have been no objections filed to these, and so they've just been sitting there. And then finally, there are 2 more petitions to which objections have been filed, but they are the following. 5010 is a petition by Holland and Knight and Freeman and Smiley for fees, both for their firm and also various other entities seeking compensation. Objections to that fee request was filed by you now, Mr. Rosengart, on behalf of your client as well. And I believe there is one filed by Lynn Spears as well. Oh, the joinder was filed by you, Mr. Weingarten, and the objections were initially filed by Lynn Spears. This is confusing. Why would Weingarten oppose a fee petition by Holland and Knight? Weingarten... Hold on. From January 19th, yeah. Hold on one second. I need to figure out... Make sure I'm right on this. Yeah, Weingarten is for Jamie Spears. Interesting. So Jamie Spears' current attorney opposed his former attorney's fee agreement or fee petition. Interesting. And then finally in this group, there is a petition at 5001, and that's the fee petition by Freeman, and Smiley. The petitioning attorney was Miss Wyle. Objections were filed to this petition by Mr. Ingham during the time he was court-appointed counsel. So you may or may not be able to say for sure about what you want to do with these today, but we need to get them addressed. And I wanted to let you know kind of the state of things with them, where there's been objections, where there's not been objections, and we have Mr. Nelson on the line, who represents Loeb Loeb, and Mr. Ingham on the line. I was like, Mr. Nelson on the line, who represents Loeb Loeb, and Mr. Ingham on the line, representing himself as former court-appointed counsel. So those petitions, I think if there's not going to be objections to those fee petitions by Mr. Ingham and by Mr. Ingham on behalf of Loeb Loeb, you might want to give some consideration to that. If they're not going to be objections, so let's get those addressed, okay? And then the next group are the ones that we're likely going to be doing today. One motion went off calendar per stipulation, 5003. That was a motion by TriStar, so that one's been disposed of pursuant to the stipulation that the court signed. 5002, I know we're going to be doing today. That's the motion concerning the request to seal or limit service of the termination plan. And then we've got at 5006, this is a petition for compensation to Miss Montgomery and Miss Wright, partial fees of which were allowed in an earlier hearing, so there is some balance due on those. No objections have been filed. And then there's at 5012, 12, there's a fee petition brought by Mr. Bronshteyn on behalf of Miss Lynn Spears. No objections filed to date on that. And then we've got the substituted judgment petition, which we did discuss at the last hearing. And then I wanted to find out today whether or not, given what we discussed at the last hearing, whether or not it's moot at this time. So that's something we want to be talking about today. Then finally, before I get to the other question I had about the orders, there is the petition at 5005. So these are all calendar items. She's just listing them off, which was recently filed by Mr. Weingarten, to which, and I just want you, counsel, to know, Mr. Rosengart, that the objections were just viewable today. So they were e-filed on the 14th, but of course, Monday was a court holiday. It was the King holiday, and they weren't posted last night before I left, but they are visible today. So the probate attorney has got to review those, fold them into the minute order. So we're not there yet in terms of having them as part of the probate notes. So something's going on outside. Probate notes are, research attorneys that go through all of the petitions and matters on calendar, review all the prior docketed items, and then they give notes to the attorneys prior to the hearing. Finally, and I'll be happy to hear people's positions on these various matters, there is the order that we discussed at the last hearing about the petition the order on termination. There was an order that is sitting in the court file that was served on everybody. I haven't seen objections to that one. Now, if everybody is in agreement on that one, then I can sign it. Then I can sign that. But if there is some dispute about that, then I want to find out what it is and for the parties to come to some consensus so I can actually sign an order. Sophie is feeling better. Thank you for asking. My daughter has COVID again. Finally, there is one order that for whatever reason, and I don't know exactly the reason, it was filed later in the process after the court made an order appointing Loeb Loeb as counsel for Ms. Spears. Somehow, and for some reason, the answers to which I don't know, it did not. I think there was some changes in the order, some modifications of the order. The final version of the order did not get to me until after the hearing on the termination. So I wanted you to know that, there's a minute order appointing them. I do plan to sign the order, although the date is going to be 2022, even though what happened was in, an earlier time. But also, since that time, of course, Loeb Loeb has stepped aside. So Loeb Loeb got appointed in 2019 or 2020 as litigation counsel for Britney Spears. Sam Ingham, her former court-appointed counsel, said, listen, if Jamie Spears is going to have all these high-powered attorneys and litigation counsel, we're going to need someone to represent Britney in a litigation capacity. I'm not going to be able to handle this by myself. Court agreed, but the order appointing them never got filed and signed. Or it did get filed, but it didn't get signed. What's interesting about that is we saw remnants of this type of lack of execution last year when, who was it? The Bessemer Trust was appointed as co-conservator of the estate in October of 2020, and the order allowing them to act as co-conservator of the estate didn't get filed, executed until June. It was a day before the hearing. COVID for the second time for Sophia. I've had it twice. She's had it twice. Tim is negative. So whatever kind of pact he made with God, I'd just like to get it on. But that's fine. So I don't want there to be any confusion by anybody that although the order is going to bear a date that's subsequent to the date that is in the petition, in the order, based on the petition that was earlier granted, and that does not change the dynamics, of course, of procedurally where we are at, except that there was an order made, the attorney order, for whatever reason, it needs to be signed. So I've given you the table for what I want people to talk about. So Mr. Weingarten jumps in, and that's Jamie Spears' attorney. So I'm going to try to make sure that you guys know who's who as we're going through. Your Honor, I'm sorry. Unless I didn't, I might have missed one that you said. I didn't hear you reference 5001. Court says, yes, 5001. Yes, I did mention that. I have to go back, but these He says, the accounting petition. The court says, yes, 5001. I did mention. That was the one that, because I don't have these grouped in order, I have them grouped by subject. So 5001, I thought I talked about, but I can certainly go back and see because I'm keeping them separated by. And then Rosengart says, Your Honor, you mentioned it in the first group, category A. Yes, that was mentioned in the first group because that's been pending. This is the 8th appearance on that one, okay? Yes, thank you. Mr. Rosengart says, okay, so let me start with you, counsel. Mr. Rosengart, oh, she says this. Mr. Rosengart on the issue about Mr. Ingham's fee request and Loeb Loeb. Rosengart says, thank you, Your Honor. We believe, and first, I want to thank you for laying out and setting the table as you did. A little groveling to the judge doesn't hurt anybody. There's a lot on the docket. The good news is, with the consent of some counsel on the screen, or the discussions with some counsel on the screen, we will be able to moot some of them and, I believe, take a couple off calendar. We're fully prepared to address, before I get to Group A, Mr. Weingarten's petition, which I believe is 5005. So Mr. Weingarten filed a petition for his fees to be paid in the same manner in which fees have been paid for the other attorneys. The difference here, Mr. Weingarten, remember, is Jamie Spears' new attorney. The difference here is we don't have a pot of money to pay him out of that's being held by the conservator of the estate. No, this happened a month ago. We don't have like somebody who's controlling the estate that's just going to write checks. And Jamie is asking for his attorney, his new attorney, to represent him and be paid for by Britney Spears. Mr. Rosengart says, I understood, Your Honor, that it was made available. I'm sorry. He says, okay. I understood, Your Honor, that it was made available online late last night or yesterday. The objections. Yesterday afternoon, exactly my objections. We did serve courtesy copies on the court both yesterday in a belt and suspenders effort, as well as Friday afternoon. We'll get to that later, but my hope is that the court, and I fully understand that the court has not had an opportunity to review our objections. They're fairly detailed. Actually, they're very detailed and are quite voluminous. They consist of two components. One is our objections in the form of what I would call a brief, along with 7 exhibits, and a declaration of somebody who's working with my office named Sharon Abadi for the benefit of the court reporter. Oh, he says EBADI for the benefit of the court reporter, who is a former special agent with the FBI. And I just want to hope or want to ask, and we can defer, I guess, the response to this, whether the court has had an opportunity to review and digest those materials. Court responds. Okay, so other than, like I said, they weren't viewable until, I can go by what's in the court file. I looked at the court file as late as last night. They weren't there, but they were posted today. Mr. Rosengart says, okay, understood. Court says, so I have to review them in more detail than what I looked at. In addition to that, the probate attorney who is assigned to this case has to also review them. Matt Rosengart says, understood. And fold them into the probate notes, which has not been done yet because they were just made viewable today. Understood. The reason I asked, Your Honor, and thank you for indulging, I think that could inform the sequencing of what is heard today. Court says, okay. Rosengart says, so addressing Your Honor's chronology, with regard to the petitions filed by Mr. Ingham, we believe that those are in effect, and this is the reason I asked about whether or not you had read our objections, as well as the declaration of former Special Agent Abadi from the FBI. We believe that those petitions are inextricably intertwined with our objections to Mr. Weingarten's petition on behalf of Mr. Spears to obtain more legal fees from Britney Spears' estate. The reason for that, Your Honor, I think will become apparent. And forgive me for not filing the objections a bit sooner. We were literally gathering information and evidence up until the date of filing. But the reason they are inextricably intertwined. So let's take a second. Let's take a breath. So Weingarten files his petition to get paid as Jamie Spears' attorney. Britney Spears' attorney files 2 different documents. One is objections with some exhibits, and 2 is a former special agent to the FBI her review of a lot of the sources of the documentaries and things that have discussed the planting of listening devices in Britney Spears' room, the mirroring of her cell phones, the surveillance of Britney and all of her communications with doctors and her attorney, all of that. So those putting before the court more than just potential hearsay on things that have been heard by, on a television series. Instead, the FBI went to those sources themselves, including the black box security whistleblower, reviewed the material, and gave her own sworn under penalty of perjury declaration. Can you guys make sure, okay, the numbers are moving. Everything was stagnant for a second. Okay. I think will become more apparent to the court once you've had an opportunity to review and digest our filings. Specifically, there is significant, very serious, specific and credible evidence of misconduct, potential criminal misconduct on the part of Mr. Spears. We have served discovery on Mr. Spears. There's discovery outstanding. It has not been responded to. We've now served 2 sets of discovery. We've served discovery on Britney Spears' former business manager. One of the issues that we're going to put back on calendar, that entity is called TriStar. We are still reviewing voluminous material sent to my office by Mr. Spears' new counsel, Mr. Weingarten. As we progress through discovery, we believe more information will come to light that bears on our objections to Mr. Ingham's petitions and Loeb's petitions, as well as in regard to the objections that we've already filed on September 28th in connection with other law firms seeking additional fees from Ms. Spears. We are still reviewing voluminous... Yeah. So they're going... Previously, they served discovery on TriStar, which is Lou Taylor, Robin Greenhill, that whole gang. And TriStar went to the court and was like, whoa, we shouldn't have to respond to all of this. And they did file a motion to quash. Then that got taken off calendar in an attempt to meet and confer and find an agreement. No agreement was reached. Looks like that's getting put back on calendar. So my point being, Your Honor, you're correct that the Ingham petitions have been sitting there. Ingham being Britney Spears' prior attorney, the petitions he's filed and his own fee petitions, I do believe. No objections have been filed yet. We do anticipate doing 2 things. 1, filing objections to those petitions, as well as serving supplemental objections to the objections that Mr. Ingham filed in regards to matter 5001, the accounting. So Rosengart saying, we anticipate, so Mr. Ingham filed objections to the accounting, the prior accounting, which is likely the 12th accounting. Rosengart saying, I'm going to supplement those objections with additional objections. We believe that because those 2 categories, or buckets, if you will, as I'd like to say, that is the accounting, which is 5001, which is not ready to be heard today. We're going to ask for an evidentiary hearing or a trial under Bennett. We need discovery, Your Honor, prior to that trial, because 5001 is inextricably intertwined with the Ingham petitions and the Loeb petitions to which we do object. We believe that those should all be folded together, folded into one hearing in regards to 5001. So the petition, Ingham petitions and Loeb petitions that Rosengart objects to, fold those into the petition, the accounting, the 12th accounting, and the approval of that. What's not clear is if the way I read what he's saying is he's going to object not just to the accountings and supplemental objections, but also possible objections to the fees collected by Ingham and Loeb. Ideally, he'd ask for a date certain when we can hear all of those in connection with the accounting. Thank you for the compliment on my eyeliner. It's the one thing that's going well today. the court says, okay, are you planning on filing, and I believe you alluded to that, are you going to be filing them separate? Because in probate, you will need to have objections if they're going to be filed for each petition and not have one set of objections in another petition thought to be connected with another petition. He says, we're going to be doing two specific things, I anticipate. Objections to each petition, as well as additional or supplemental objections to the accounting, which is 5001. We can do that by a date certain. We'd like to pick a date now. We believe that must be an evidentiary hearing under Bennett. Bennett is a case, and I know that because it's underlined. Let me see. Evidentiary hearing Bennett. Let me see if I can. Final account and petition for distribution together with said objections came on for hearing. Interesting. Okay. We would suggest maybe 150 days, and we'll file our objections as well as our supplemental objections 30 days before that. So they want an evidentiary hearing 150 out, which is 5 months out. We're 1 month out there. So this would be, we'll see when they said it. The reason this time, Your Honor, is appropriate, and I understand these matters were languishing to some extent before my firm's involvement, is prior to my law firm's involvement, no discovery was served. Respectfully to Mr. Ingham, no prior discovery was served. Once we got involved, given what we saw, given Ms. Spears' testimony, we served discovery on Mr. Spears in the form of requests for admissions, interrogatories, special interrogatories, and document requests, of course. Those were initially not meaningfully responded to. Those were geared toward the September 29th suspension and removal hearing. So discovery, if we want to take a walk back, is the request of information from one party to another. Sometimes not even a party. But in this case, the specific discovery we're talking about is written requests for information. Interrogatories are questions. Special interrogatories are written questions written by, in this case, counsel for Ms. Spears. He wrote down, I think one of them was, did you have a romantic relationship with Lou Taylor? I think that was a request for admission. So admit you had a romantic relationship with Lou Taylor. Question would be, how much money and fees did you take from Britney Spears' estate during your tenure as conservator of the estate? Document requests, we call those production of documents, demand for production of documents, provide all documents related to the expenses incurred for the Louisiana home occupied by Lynn Spears. And then they would have to provide all documents. They have 30 days plus however long, it's usually 5 days, plus an amount of time related to how the document was served. So you get 30 days to respond to the document, but if it was served via mail, you get an additional 5 days. If it was served overnight, you get an additional 2 business days, yada, yada, yada. Okay. Those are in the record as part of the objection that we filed on Friday as Exhibit 7. So we haven't received responses yet to those. There have been no responses at all. There haven't even been objections. Secondly, Mr. Weingarten has, on an informal basis, so Jamie's new attorney has, on an informal basis, understanding that he has a remaining, or his client, Mr. Spears, has a remaining fiduciary obligation to the estate. They have produced voluminous information to us. We strongly take issue with the manner in which that information was produced. It wasn't labeled. I don't think it was bait stamped. It doesn't respond to our categories of informal requests. And now I'm referring to the informal transfer of files as opposed to the formal discovery that we've served. So what he's saying is Jamie Spears has a continued fiduciary responsibility as prior conservator of Britney Spears' estate to ensure that there's a seamless transfer. Maybe seamless is too onerous, but to ensure that there's a transfer of information to Britney Spears' new counsel or to Britney Spears. And what it sounds like happened is just like, well, all of the, I've got here's papers. You know, here's papers. Put it in a box. Here you go. Nothing was numbered. It wasn't labeled, and it didn't correspond. So here's stack one. Stack one relates to your request, your informal request for documents number 1. Thank you. And that makes it a lot harder to get information categorized correctly. I don't know that that's Jamie's, will she have to pay for his legal counsel? We're getting there. So we've been hindered in that regard. There are no files that have been transferred to my knowledge, although my team is still reviewing it pursuant to the cases of Moeller for the court's reporter benefit, Moeller, and Stein, Stine, pursuant to which, Your Honor, we believe we are entitled to communications between Mr. Spears on the one hand and his counsel on the other hand regarding matters that are at the heart of this matter now, notwithstanding the termination of the conservatorship. So that's interesting. I had not heard that prior to reading this transcript, that despite the fact that Jamie Spears has started transferring files, documents, communications, all of that to Britney Spears' new attorney, I guess he's not new anymore, he's been there for 7 months. Despite that, specifically, part of the reason Britney Spears' attorney removed Jamie Spears, instated a new conservator of the estate, and then terminated the conservatorship was to transfer that attorney-client relationship to the new conservator so that the new conservator had access to the communication between the prior conservator and his attorney. That's really important because generally attorney-client communication is barred from discovery. That is a privileged communication. My conversations with my client, as my client sits, those are our communications. So instead of a lot of people were really upset with Rosengart for taking his time to terminate the conservatorship, but it was extremely important that he make sure to transfer conservatorship first and then terminate, so that there is a line of cases that requires that it's not Jamie Spears' attorney-client communication privilege. It's not his privilege that he holds as an individual. He holds that privilege as the conservator, not as an individual Jamie Spears, so that when he steps back as Jamie Spears, if he held it as an individual, it would remain with him. Rather, the privilege stays with the conservator of the estate. So Jamie Spears steps back, privilege stays here. John Sable steps in. John Sable now retains that attorney-client communication privilege and gets to read all of the privileged communication between Jamie Spears and his attorney and attorneys. But despite the start of the transition and documents, none of those communications have been provided. Specifically, as we know, the New York Times reported on September 24th in a front page story, followed by a documentary, that Mr. Spears was involved and or instigated a very intense and potentially illegal surveillance apparatus on Miss Spears that included 2 specific things at least. One was the monitoring of phones that were being used by Miss Spears in real time and contemporaneously capturing those text communications, including, most troublingly, communications between Miss Spears and Mr. Ingham. In other words, attorney-client communications were effectively being monitored, captured, and reviewed by James Spears in real time. This is what is so fucking infuriating, is it's so easy in this case to get wrapped up in James Spears versus Britney Spears. But that's not what this is. This is fiduciary of Britney Spears taking advantage. I mean, James Spears has no right to Britney's money outside of this conservatorship, and his only right to her money is to make sure that it's working in her best interest for her purposes. And instead what he has done is craft this conservatorship, as they called it in one earlier filing, a quasi-business relationship conservatorship. Like basically this is like a corporation. We're taking Britney, putting her into a conservatorship, and then molding that into a corporation. So Jamie, where he would usually sit as conservator of the estate and Pearson in a conservatorship, instead he's almost acting as like CEO of Britney Spears the person. Does that make sense? So in a regular conservatorship, all you have to do is make sure that the person has a place to live and make sure that they've got access to medical care and make sure that they're being taken care of. Like the theory is they can't do that for themselves. Instead, they have somebody that can help them. What he did is he took Britney and was like, money-making opportunity, make money. Hybrid business model, I think they called it. Exactly. Is that legal? Well, that's the question. Problem is, Britney Spears' attorney never objected to, well, he started objecting much later on, 2020 or 2019. But this went on since 2008 and has moved forward through Las Vegas residencies, through world tours, through albums, and her attorney never spoke up. Now, there's a lot of speculation about why he didn't. He did have quite a bit to gain. When you have a client who you are able to bill, I think the maximum he could bill was like $10,000 a week. I don't know that that's actually what he was billing out. But he was able to make a lot of money off of this conservatorship. And he didn't put a lot of effort into stopping it. But it's very interesting that Jamie Spears has not turned over his attorney-client communication, but contemporaneously watched Britney talk to her attorney. Therapy notes were being reviewed. In the evidence we believe shows and will show by Mr. Spears, even though to the credit of his counsel at the time, Mr. Spears was worried that he did not have a lawful right to review Britney Spears' therapy notes. My point being, Your Honor, in regard to this bucket of information, the informal discovery that Mr. Weingarten's office has provided that we're still reviewing, we have not seen any of those materials. In other words, we've seen no Mueller-Stein materials. We know that the surveillance occurred, the second category of surveillance, putting aside what was done in regard to Ms. Spears' phones, was a listening device, according to a whistleblower who worked for Black Box Security. Ms. Spears' security team placed a listening device, a secret listening device, in the bedroom of Britney Spears. I'll say that again. Black Box Security, at the direction of Mr. Spears, the evidence shows and will continue to show, placed a listening device in the bedroom of Britney Spears. Yeah, therapy notes. That information is information that we're entitled to formal discovery on. That information is information that we're entitled under Mueller versus under the Mueller case and the Stein case to receive information on a non-adversarial basis from Mr. Spears. Is there an opportunity for a criminal or civil case against Jamie and conservatorship lawyers? Yes, part of that's what's happening here. This is teeing that up. Why doesn't the judge act faster? Because these acts are horrible that they did to Britney. Let's see how this plays out, and if you stick around, I'll try to answer that at the end. People should be aware that for a time she was probably okay with working due to it being normal. Possibly. One of the issues that we have, Your Honor, is there's very strong evidence that both of these things occurred under the EGI's, I think that means under the guise of electronic surveillance. The real-time contemporaneous monitoring of Britney's phones and the placing of a listening device in her bedroom. If, in fact, those things occurred, and they did, according to the whistleblower from Black Box Security, whose statements were corroborated recently by former FBI special agent Shirin Abadi of my office, then it stands to reason that there were internal communications between Mr. Spears on the one hand and his representatives on the other hand about these issues. So what Rosengart's saying is, we know that we're entitled to attorney-client communication between James Spears and his attorney. We also know that James Spears had listening devices placed in Britney Spears' room and contemporaneous surveillance devices of her phone and iPad. Those two, it's highly unlikely that James Spears did nothing with that information, right? So he's saying they talked, James Spears' attorney and James Spears talked about the things that James Spears was witnessing or Black Box Security was witnessing, yada, yada, yada. Like, they must have discussed this and were entitled to the communication in which they discussed these illegal acts. Not one document in that regard, despite our repeated requests, both in terms of formal discovery and informal discovery, has been produced. Now, just circling back to my point, and I've only alluded now to one category of 12 categories of misconduct that we believe we will prove with overwhelming evidence that Mr. Spears engaged in. But once we have this additional information, it's going to shed light on these other categories, the petitions filed by Mr. Ingham and the other petitions. So while only scratching the surface on the alleged misconduct of Mr. Spears, we believe it makes sense for reasons of economy and efficiency to let discovery run its course. Hopefully, we will be able to get informal discovery under the Mueller-Stein cases. We need additional time, frankly, Your Honor, to review the documents that have been provided. Although, again, the documents that have been provided, although, rewind, reverse. We need additional time, frankly, Your Honor, to review the documents that have been provided. Although, again, we've got issues with respect to the manner in which they have been provided. And then we think it makes most sense to fold the petitions into the evidentiary hearing that will occur, we hope, at a date certain. Court says okay. So that's part of the reason. Somebody asked earlier, why doesn't the court just get this done? Rosengart's not asking for the court to act on these requests now. He's saying, tee it up, tee it up, tee it up, send requests. Because if they continue to shield information or fail to respond to discovery, not only could they, have to turn that over, they could get sanctioned. The attorneys, the parties. If Mr. Spears doesn't give that info, can Rosengart use the tapes that New York Times heard? I think those are already in Rosengart's possession. Jamie Lynn's interview let us know Jamie was privy to her conversations with Sam. From her testimony about crying on a phone convo, him seemingly enjoying her frustration, creepy. Are you okay? It keeps sounding like you're holding back tears. Maybe just me. No, I'm not holding back tears. Not today. Well, that's not true. I'm in a fucking horrible mood. It's okay though. Was it able to be proven in court? What is able to be proven in court is very difficult. Correct. But Rosengart's not dumb, and he's got people that are setting this up to be able to be admitted in a hearing. That's why he's asking for an evidentiary hearing. Are the tapes accepted by the court even though they didn't come from Mr. Spears? They can be, as long as they're authenticated. And you might not even need to admit the tapes. If you can get Black Box Security to come in, that's not hearsay, and say, I surveilled Britney Spears as a part of my duties for Black Box Security, then the question would be, who told him to? Is that hearsay? Is there a exception to the hearsay rule? Those kind of things. Has this crossed over into a crime yet? Allegations are yes. Court says, okay, thank you, counsel. Miss Wiley says, Your Honor, this is Geraldine Wiley. Wait, Miss Wiley, hold on just a second. I wanted to circle back to you, of course, Mr. Ingham, Miss Thoreen, and Mr. Nelson. So Miss Wiley, yes, go ahead. Your Honor, for the record, we request to make a motion to strike any statements made by Mr. Rosengart. They are not of his personal knowledge, and we'd request that he limit his comments to argument rather than allegations, which he does not have the personal knowledge of at this time. That is interesting because it's argument is not factual evidence. You can make arguments based off of hearsay. You can present arguments based off of things that aren't in evidence. Arguments themselves, again, aren't evidence. Striking statements from the record in an argument is not typical. The court says, okay, well, Miss Wiley, he was making his own argument, which I understand. I mean, I didn't consider it beyond anything other than that because we're not in a trial right now. I understand, Your Honor. Which, one of two things. Three. One, you're making that statement, Wiley, Geraldine Wiley, to make the public aware because this is a very public hearing, that you think that he doesn't have personal knowledge of that. Two, no, yeah, or you're just dumb because you don't know how this works. Like, do you not know that it's an argument and not an evidentiary hearing? Anyway, court says, okay, Mr. Ingham, did you have anything that you wanted to say at this juncture? Yes, Your Honor, thank you. This is Sam Ingham. I'd like to respond briefly to Mr. Rosengart. I think the court obviously anticipated that my petitions would be approved, as did I. They've been around since March of last year, and there have been no objections to any of them. For the first hint that I had of any objections to my petitions was at about 12:30 this afternoon when I was advised by Mr. Rosengart that objections would be filed. I have not seen those objections to Mr. Ingham's fee petitions. Ouch. And so at this point, I have no basis on which to respond to his objections because I don't have any idea what they are. I'm not Mr. Spears and I'm not Mr. Spears' counsel. And any attempt to hypothesize some kind of a connection between Mr. Weingarten's fee petition and my fee petition, Mr. Weingarten and I were not even on the case at the same time together. There clearly is no connection between his services and my services. And at this point, if Mr. Rosengart is going to file objections to my fee petition, I will respond to them and the court will deal with them as it has dealt with all the other difficult issues in this case. We will reserve the right to. There are obviously ethical issues involved in services rendered to Ms. Spears, which relate to her litigation that's still pending with the other parties. It's going to take some time to figure out how to handle this best so as not to damage her position with regard to pending litigation. So what's interesting about this is the person talking is her prior counsel. Britney's current counsel is saying, we're going to object to her prior counsel's attempt to get more fees out of her estate. He is not owed all of this money. We're going to file objections. And her prior counsel saying, okay, I don't know what those objections are. I'll respond when they come in. But it's a very tight walk between defending yourself and your work and protecting that attorney-client privilege, because he does still retain a fiduciary duty, ethical obligation to Britney Spears as her prior counsel. Make sense? But I am here and ready to advise the court and to present my view of everything that has happened since this, covered by the petitions that are pending before the court, and I welcome the opportunity to deal with these issues if that's what Ms. Spears wishes to do. The court says, thank you, Mr. Ingham. Mr. Nelson. Yes, Your Honor, thank you. Mr. Rosengart began his comments by expressing the view that hypothetical contemplated objections to Loeb's fees. Oh, Mr. Nelson is with Loeb Loeb, I believe. And Mr. Ingham's fees were inextricably linked, I think were his words, to detailed objections regarding managing to file to Mr. James Spears' fees. I then listened very carefully to Mr. Rosengart as he went on for quite some time, but never once did a single thing, anything that he said that links any of the very limited services that Loeb Loeb performed over less than a year of time to any of his complaints about Mr. Spears at all. There is no connection. So what Loeb Loeb is saying here is Rosengart is going to file objections to Ingham and Loeb Loeb. Loeb Loeb was Britney Spears' attorney, litigation counsel. Rosengart saying their fees are inextricably linked with the fee petition of Jamie's current counsel. And so he wants to litigate all of it. And Loeb Loeb is saying, whoa, we were involved in this case for less than a year. And I didn't hear anything that linked us, Loeb Loeb, with anything that James Spears did. There is no connection. Loeb Loeb never represented Mr. Spears, never had anything to do with Mr. Spears. We were associated litigation counsel for limited purposes for a limited period of time. Our petition, Mr. Ingham's petition for Loeb's fees, has been pending for almost a year now. We have graciously said nothing as parties when the court wanted to continue it from time to time to deal with other more exigent matters. But it's really time to rule on that petition. We would like to have a ruling on that petition today. It is not contested. Let Loeb Loeb get out of this now. If that's not going to happen, then we would ask the court make sure that whatever other orders it makes today retains a reserve and authority in a temporary conservator to pay our fees once they are finally approved and ordered. So we're not linked to Weingarten's fee petition. We didn't work for Mr. Spears. Nothing that Rosengart said has alluded to any wrongdoing on our behalf. We've been asking for our fees for a year. We were only counsel for less than a year. We've did very limited work on this matter. Also, to the extent you don't agree with that and you want to put this fee petition off, because I want you to rule on it today. If you don't, maintain a reserve. Don't give Britney all of her money. Don't set it all up for her to take. I want to make sure that I can get paid out of whatever's left because I'm owed that money. That's what Loeb Loeb is saying. Which is important because it means, one, we've got a lot of money that we still need to get out of this estate. And two, I don't trust Britney to pay it to the extent she gets ordered to pay it. Vivian Thoreen. Yes, Your Honor. Thank you. I appreciate Your Honor trying to allocate the various matters. I'm wondering, though, despite the fact that our fee petition has been lingering for some time, I appreciate that objections have been filed and wonder whether this is connected to the other current fee petitions insofar as the fact that they're at issue. They're opposed, and so I think we need to get into discovery, take some depositions, and if necessary, have an evidentiary hearing. That's Vivian Thoreen. So she's saying, yeah, the fee petitions have been filed. There's some objections on file. We just need to have an evidentiary hearing. Now, buckle up. Mr. Weingarten's going to speak. And this is where it gets very heated. Mr. Weingarten. Counsel, did you have anything you wanted to add? I do, Your Honor. Thank you. Let's start off with the areas we agree on. They're limited, but they do exist. First off, Your Honor, had mentioned before counsel's comments the proposed order that had been submitted regarding the termination of the conservatorship. That is something that was specifically negotiated amongst all of the appropriate counsel and everyone signed off on it, so it is stipulated by all parties. I thought that everyone had actually signed what was submitted to the court, so that's ready for the court's execution. The other things that we can agree on is that we need to set for hearing the accounting petition, and I would ask that that be set as soon as possible. I would say 90 days. 150 days seems unnecessarily long, but it seems we all agree that should be set for hearing. The difference between 90 days and 150 days is the difference between serving discovery, getting responses, being able to file a motion to compel and serve supplemental discovery, 150 days, and being able to serve discovery, get responses, review for trial, in my opinion. Moving on to the areas that we disagree on, and unfortunately, there are quite a few. I also only received the objections that were filed by Mr. Rosengart late yesterday. After 6 o'clock yesterday is when they were finally served on me, and they were served by mail. I will note that I received, and I counted, 27 different media inquiries about those objections, meaning 27 different members of the press who had received counsel's objections before I did, and then they still had time to reach out to me after they had read them and digested them, asking me detailed questions about them. So I also have had very limited time to digest what it is that counsel filed. I can tell you that in that time, I believe, and we will establish to the court, that they're all nonsense. I'm telling the court right here and now that virtually every statement that's made in those objections is either demonstrably false or taken out of context. And that's not something to resolve right now. I appreciate that.
Hey, my food.
Thank you, babe.
It wasn't as good looking as I expected. It was yummy.
Okay.
I'm full.
Awesome. Sorry. Why would Rosengart file so late? He says he was accumulating evidence up and until the hearing and service of the opposition, the objection. I'm telling the court right here and now that virtually every statement that's made in those objections is either demonstrably false or taken out of context. And that's not something to resolve right now. I appreciate that. But it's important that it be stated because obviously there are proceedings that are being covered and watched by the world. So I want everyone to hear that virtually everything that is alleged in those objections is either demonstrably false or taken out of context. In that vein, a lot of what is being alleged is based on media reports. And what's happening now is that counsel selectively leaks sealed information to the press. Big fucking deal. Big fucking deal. Then the press then reports that, and then counsel cites those press reports based on his selective and misleading leaks to the press as quote unquote evidence in support of the theories that he's advancing. So, hey Sandy. So what he's saying is Rosengart is leaking sealed information to the press. Like, here's a sealed document that no one has access to. I can't get it off the court's website. Here's a sealed document to the press. Then Rosengart's turning around. The press is reporting on it. Rosengart's then coming into court and saying, look at what the press is saying. That doesn't make any sense because that means Rosengart would just be arguing what's already in the court record. That doesn't bear any weight. So he's saying Rosengart's leaking sealed information, private information to the press. The press reports on it. Rosengart then comes into court and says, oh, quote unquote, this is evidence to support my position, when it was really him that leaked the information to the press in the first place. And so on that basis, Your Honor, I'm going to ask the court for permission to set a hearing on a motion to unseal the court file in this case. I intend to file that motion next week, and I'd like it to be heard on February 17th, so that that portion of this can be dealt with. Because the problem that we're dealing with right now, Your Honor, and it's not just me and my client, I believe it's all the parties, is that we're fighting with both hands tied behind our backs. Because Miss Spears, through her social media accounts, and Mr. Rosengart, through his and press statements and his press conferences that occur after each of these hearings, say things that we all know to be false. But we are constrained by our fastidious adherence to the court rules and not discussing sealed information. The public clearly has a right to know the truth here based on statements by Miss Spears and her counsel. So we ask that the public actually get the truth and know everything that has gone on, because we know that it will vindicate us and it will demonstrate that there is no merit whatsoever to all of these specious and irresponsible allegations that are being moved. Right? What sealed information? I don't know. I'm not done, counsel. I guess maybe you're sweet. I guess maybe Mathew Rosengart was going to say something. I'm not done, counsel. As far as the timing in the fee petitions relative to the accounting petition, I disagree predictably. And we believe, Your Honor, the law, I appreciate that, given the timing of the filing of the objections and the fact that the court has not digested them yet, that there is not going to be a ruling on our fee petition today. I also want the opportunity to be able to respond to the objections and the allegations that are asserted. I believe that once we have the opportunity to do that, that under Casper Bauer and its progeny, and even under Stein, that we're entitled to the fees pendente lite? Dente lite? I haven't seen that. Google. All these words are pronunciation, so that I don't get it wrong and people don't yell at me in the comments. Pendente, let's see. Oh, do I have it on mute?
Pendente light.
Pendente light. I did say it right. Awaiting litigation. All these people with all these fucking Latin terms. Anyway, awaiting litigation. And it is appropriate under California law and a matter of public policy for us not to have to wait. My clients do not have to wait to have fees advanced pending the outcome. So funny because the way he's couching this is like, you can't make Mr. Spears wait. That's not fair. But Mr. Spears isn't waiting, dude. It's you. Like, you're the one that's getting paid out of this fee petition. James Spears is fine. You're the one that's going to get your pocketbook enhanced. The idea here is that counsel was trying to hamstrung my client and choked him off from his ability to have conservatorship estate fees available to defend himself against allegations, bogus allegations that are implied. That's not what the law provides, and we will establish that. That's fucking hilarious. Think about what he just said. They choked James Spears off from estate fees available to defend himself against allegations. There are allegations against Jamie Spears, and his counsel thinks he should have the vast amount of money available to him as part of Britney Spears' estate to use to defend himself. It's quite the position. So I would ask the court to bring us back relatively quickly after the court has had the opportunity to digest both the objections and our responses thereto, so that we can address that issue much sooner than the actual hearing on evidentiary hearings on the accountings. And then finally, I want to address the allegations that have been made about our level of cooperation and discovery. And these allegations specifically regarding electronic surveillance, okay? I got involved in the case in October, okay? My client's direction, as I communicated to Mr. Rosengart, was that we had nothing to hide, and therefore we would hide nothing. And based on that, I instructed prior counsel to hand over their entire files directly to Mr. Rosengart. Actually, it was Mr. Gold who was acting as counsel for Mr. Sable at that point, who then provided them to Mr. Rosengart in his office, okay? I don't know what's with all these okays. If you cannot afford an attorney, one will be appointed for you. Yeah. So he can't use money he was wrongfully accessing to defend himself from the conservatorship. Exactly. My understanding, and I have also received those files and I have reviewed them, is that it was a comprehensive handover of all the files. There was no instruction to withhold documents on the basis of privilege. Indeed, privileged communications between Mr. Spears and his prior counsel are referenced in the objections that were filed by Mr. Rosengart is evidence to the fact that we provided them. Privileged communications between Mr. Spears and his prior counsel are referenced in the objections filed by Rosengart, and that's evidence that they provided them. I don't remember any reference to privileged communications, but it's been a month since I've looked at this. The argument now is, I have a theory that this illegal conduct occurred. I have no evidence of that theory other than things that the New York Times said and that I planted with the New York Times. So, Weingarten's saying this is Rosengart's position. I have a theory that this illegal conduct occurred. I have no evidence of that theory other than things that the New York Times said and that I planted with the New York Times, I being Mr. Rosengart in that scenario, just so we're clear on the record. There must, therefore, be evidence of that. And the fact that it doesn't exist means that you're hiding it. Nonsense, Your Honor. Utter and complete nonsense. I know that information that is under seal has been provided to Mr. Rosengart that conclusively disproves the allegations that he's making, not just about electronic surveillance, but about lots of other issues that are raised in their objections. He has the information, whether he's looked at it or not. I can't tell, but I know he has the information. The public doesn't have it, and therefore, I go back, finally, Your Honor, to this need to unseal the record. We need the truth to come out. Part of the story, a misleading misrepresentation of what actually occurred over the 12 years of this conservatorship, actually needs to be told, because in reality, the allegations that counsel is making are not just against my client. They are against Mr. Ingham and Mr. Wallet and against this court, because everything that was done over that period of time was approved by Mr. Ingham and or Mr. Wallet and or Judge Gates and or Your Honor. So that's a really interesting strategy. The idea that, and this is not the first time that this has been surmised by counsel for James Spears. Listen, what Mr. Rosengart's saying is, serious, and it's not true. But to the extent it is, that accusation is not just against James Spears, my client. It's against the prior conservators. It's against the prior counsel for those conservators, against the prior counsel for Britney Spears, and even Your Honor. Like, you court approved all that stuff. So if anything went wrong, that's on you. So we shouldn't find anything wrong because you didn't do anything wrong. A bunch of you are commenting on my eyeliner. I really appreciate it. Putting it back on the court. Free pass because allowance and willful negligence. Yeah. Isn't that kind of threatening to the court? Not threatening. It's a tactic. The court, gentlemen, we're not going to be trying the accounting or anything else. This is a calendar call. So let's try to keep our comments. And Mr. Rosengart says, understood, Your Honor. I am compelled to respond to a number of direct false statements and lies told by Mr. Weingarten to the court and the media. Lies. And I've been generous, and I've been reticent, and I've been circumspect, but he has attacked me, he's attacked the court, and it is intolerable. And what makes it most intolerable is that he knows he is lying. He knows that he is lying. He has a strategy here. And his strategy is to make a false accusation and try to go on offense. One thing I agree with in all of what Mr. Weingarten said is knowing false statements to this court is the following. The public has a right to know the truth. Now, Mr. Weingarten, in his speech, didn't say one thing about whether or not his client knew or directed electronic eavesdropping on my client, both in terms of capturing her relative communications on her phone, including communications between Ms. Spears and her lawyer, and placing a listening device in the bedroom of my client. Mr. Weingarten, didn't happen, Your Honor. The court, wait, the two of you, let's just bring the temperature down. Mr. Rosengart. Now, Mr. Weingarten said, and he just made accusations, Your Honor, that are disgraceful, and he should be ashamed. He says it didn't happen. Then let's see what Mr. Spears says under oath when he's deposed. Now, I did not, and this is crucial, I did not initiate these allegations. I've learned about these allegations along with the rest of the world when the New York Times published its documentary and published its front page story based upon its interview of a whistleblower. The notion that according to Mr. Weingarten, and it is factually nonsensical, and I'll say it to his face, is false, that I somehow planted this quote unquote story with the New York Times is preposterous. I am going to put this on YouTube. And he should be admonished as an officer of the court for daring to say that. Maybe that works in other courtrooms that he practices in. I have great respect for Your Honor, but he should be admonished from doing it in this courtroom. I learned about those allegations when I read about them and when I watched the documentary on September 24th. Now, let's talk about them for a minute because he boldly staked out his grounds and said it didn't happen. And worse, outrageously and disgracefully and falsely that I planted them. That's his strategy, and it's ridiculous. His strategy is when you're on defense, try to go on offense. It's so transparent and it's so disgraceful, he should be admonished. Court says, okay, counsel. Rosengart, the allegations come not from Your Honor, and I'll briefly sum up because I could go on for 3 hours with specific facts. They're in our filings. Not only did they not come from my office, Your Honor, they came from a whistleblower who worked for Black Box Security. The New York Times corroborated what that whistleblower said in their front page story. This is not the National Enquirer. Fucking National Enquirer gets blasted. This is the New York Times. They worked with the whistleblower. They interviewed the whistleblower. They debriefed the whistleblower. They corroborated the whistleblower through documents that they obtained from the whistleblower before. Obviously, I had any knowledge of that. Then, and these are facts. This is not a, quote, theory, the word Mr. Weingarten used. My office retained a former special agent with the FBI named Sharon Abadi, who also had the honor of working with special counsel Robert Mueller, whose integrity is above reproach. I don't know that everybody's going to agree with that statement. And the likes of Mr. Weingarten should not attack her, let alone me. Miss Abadi, and I appreciate that the court has not had an opportunity to review our objections, but when you review Miss Abadi's declaration, her declaration was long, the court will see that Miss Abadi herself, after the New York Times article, very diligently did what anybody in our position or her position would do as a matter of duty. She interviewed and she debriefed Mr. Vlasov, the whistleblower, for hours, and she herself, based on her training and experience with the FBI, and I dare say she knows a little bit more than counsel, has deemed him credible. And she has reviewed certain information from his personal computer that corroborates not only the New York Times story, but her own debriefing of Mr. Vlasov. So I think we should ratchet down the rhetoric here. The court, okay. Rosengart, we should go through discovery. The court, first of all, we're not Mr. Rosengart, and we shouldn't be making these bold-faced false statements as Mr. Rosengart just did. Court, Mr. Rosengart, thank you. We're not going to be litigating because that's what it's turning into. We're not litigating the accounting and the objections and the request for fees and all that now. What I want to do today, I really want to, bring these issues to your attention about matters that have been, to my mind, kind of languishing while we're here handling other things. But we need to get everything on track. Mr. Rosengart, Your Honor, I understand, but he should withdraw his false statements. He has a right to play hardball if he wants. He does not have a right to challenge my integrity, Special Agent Abadi's integrity, and lie to this court. Court says, I understand. Rosengart, he could be a devil's advocate. He cannot lie, and he knowingly did that. Court says, counsel, Mr. Rosengart, and that should be withdrawn, Your Honor, by Mr. Weingarten. Okay, Mr. Rosengart, or he should be admonished. Court says, well, the truth of all of this is going to come out in a hearing, okay? So I'm not deciding what's true and what's not true today. Important to note, because I want to make sure we're fair. Remember earlier when Mr. Rosengart gave his statement on his initial statement, and I think it was Geraldine Wyle came back and was like, we request that the statement that he gave be stricken from the record because he's testifying on things that he doesn't have personal knowledge of. And the court said, wait, this is an argument. This isn't testimony. So Rosengart is, in some senses, saying he needs to withdraw his false accusations, which is different than testimony. But he's saying that Weingarten's statements are so far out that the court should admonish him. But the court's not going to litigate whether or not they're such bold-faced lies that admonishment is necessary. Does that make sense? These people are playing checkers and Rosengart playing 3D chess. Everybody keeps saying that. The other thing I want to let everybody know about is that I don't know what an ultimate trial estimate would be, but if it's going to be a long cause trial, it will go to our long cause courtroom that we have it for probate. We have a long cause courtroom. So there's a hearing, which is like this, would take about this amount of time. Long cause is like half a day, full day, couple days, where it goes to a different courtroom because this courtroom cannot take up its time for days because she has other matters that are set for hearing for on regular calendar basis. So this isn't a trial courtroom. So that's why it would go somewhere else. And that happens in a lot of courts. One thing that has to happen before any matter can go to trial is if all these... One thing that has to happen before any matter can go to trial is all the discovery has got to be completed. So we wouldn't be setting a trial date today because I don't know when your discovery is going to be complete exactly. But when it is, I will get you over to the long cause courtroom and you will be assigned a trial date, okay? And the other thing is, I know that both Mr. Ingham and Mr. Nelson indicated that if you're going to be filing objections, they need to have some time to respond to them. So one of the things I want to do, because we still have a few other matters we need to get to, is we need to set up some file by dates to file objections to Mr. Ingham's petition and to they're all Mr. Ingham's petitions, but 3 of which are Mr. Ingham's petition for his own fees, 1 of which is a petition. The 4th one is a petition for fees for litigation counsel. How soon can you get objections filed to the petition that Mr. Ingham filed for fees and Loeb and Mr. Ingham's 3 petitions? Rosengart says, the answer rests on when we will receive the responses to our outstanding discovery requests that were served approximately 30 days ago on Mr. Spears' counsel. So if we can hear from Mr. Weingarten, we can sort of reverse engineer and set a date because we think we need that discovery. We know we need that discovery as it may form our objections. So the court's saying you need to respond to Mr. Ingham's fee requests. For his fees, for Loeb and Loeb's fees, you need to respond. You need to file your objections so that they can respond. What date do you need to file those by? Like, how long do you need? And he says, well, we've got pending discovery out. Sorry. Okay. So Rosengart saying, it's okay, Steph. I figured you'd get it. Weingarten saying, let's hear from Mr. Weingarten and when his client is going to respond to discovery, because the discovery responses from James Spears are going to form the objections to prior counsel for Britney Spears fee requests. Does that make sense? We heard from Mr. Weingarten. Responses were provided yesterday. They were served by mail. So Weingarten saying that Jamie Spears responded to discovery, whatever the day before this was. I think would have been the 18th of January, I think. Rosengart says, we heard from Mr. Weingarten about his issues with service by mail. We'll look for them in the mail. I would have appreciated had that been served electronically, but that said, we have not had an opportunity to review them. I don't know if documents were provided or just objections were made, as Miss Thoreen did. So what can happen with discovery, often, especially with counsel like this, is all of these discovery requests are sent. 40 requests for admission, and a bunch of questions, interrogatories, and production of documents, and they respond, but it's just, my phone's dying. It's just objection. It's just objection after objection after objection. So it's not actually a response. Gotta plug my phone in. Maybe. He's also an attorney and could be chasing clout, but with good intentions. With that said, I just want to make sure that we have enough time to review the responses, and perhaps we should get back to the court, because as much as I'd like to set a date now, it could be premature. The court. Well, let's set that aside for a minute, because I have a feeling that what I was going to talk to everybody about too probably is going to be a date in February that I need to get you back in here so you can talk about file by dates. Then, because by that time you'll have a chance to review what was provided, digest that information, and maybe have a better idea about it. Rosengart, come back with a date for objections. Okay, the court. So, and I haven't forgotten about you, Mr. Jones, and you, Mr. Bronshteyn, but your petitions are over here in another stack. You aren't priority. We'll circle back and get to those right now. We'll circle back and come to these right now. So what I have that was in, let me just tie up that last loose end, Mr. Rosengart, the order that was from before the court, so termination, everybody, we saw proof of service. We saw maybe, I don't remember if everyone signed off on it or not. That's the one that everybody agreed to, right? Yes, Your Honor. Okay, then that will be signed. So it will be signed this week. So what I have in front of me now, and then we'll circle back to these other items, is I have the motion that was filed for Miss Wright for the sealing of the limitation of service of the termination plan. So I plan to deal with that first. And then we've got you can tell me where things stand with this motion for, this petition for substituted judgment. That got taken off the calendar. And then fee petitions. No objections filed. I'm not going to spend the party's time talking about the court's authority on the motion to seal, but I will just focus in the application on the facts of this particular case. California Rule of Court, Rule 2.550, supports sealing the termination plan. Through the present motion, who is this? This is the court, yeah. Through the present motion, temporary conservator Jodi Montgomery asserts that the termination plan should be placed sealed pursuant to California Rule of Court 2.550. Ms. Montgomery asserts that the termination plan should be sealed in full, as there is no right of public access to conservatee's private medical information under HIPAA and the California Confidentiality of Medical Information Act. Upon review of the case file, the court notes that no opposition or objections have been filed, unlike previous motions to seal in this proceeding. As noted above, the court may seal the record if it finds facts that establish the following. There exists an overriding interest. I'm going to kind of go through this. We know that they seal it. I want to see if there's an argument against it. Substantial probability of prejudice to the conservatee. Court finds that the conservatee's overriding interest will be prejudiced if the record is not sealed due to conservatee's overall right of privacy. Due to the unprecedented media attention received by this proceeding, it is plainly apparent that conservatee's overriding interest in privacy over her medical and private affairs will be prejudiced if the record remains unsealed. Termination plan is highly confidential in nature and involves the transitional plan in place following the end of the conservatorship. Leaving this record unsealed is likely to further jeopardize conservatee's right to medical privacy. In addition, Ms. Montgomery argues that the proposed sealing is as narrowly tailored as possible. However, notably, the proposed sealing is for the entire termination plan. Plan will be unavailable to public access, which is not narrowly tailored, as this sealing does not allow for selected public disclosure. So even though it does say conservatees, because that was part of the workup, the court would note for the record, of course, that Ms. Spears is a former conservatee. So anyway, the motion is granted. Substitute judgment gets taken off, withdrawing that petition. Need authority for him to transfer the remaining conservatorship assets to Britney within 7 days. David Nelson, may I be heard? Sorry to interrupt, but what I have to say is very germane to this subject. We are concerned with any order authorizing or permitting the transfer of all conservatorship assets out of the conservatorship of the estate. There are petitions for very substantial fees pending that would be payable from this estate. And we would need a reserve of the estate to pay all of those fees, as well as the fees that we are going to incur from this point forward for litigating those fees. Okay, Mr. Weingarten, Your Honor, I'm sorry. Mr. Nelson didn't have the benefit of participating in the last hearing, but I want to remind the court that Mr. Rosengart made a representation to the court that funds, to the extent they are successful, the funds to pay all the pending fee petitions would be reserved and held so that, again, if the pending fee petitions were granted, there would be funds available to pay all of them. This is interesting. So Weingarten, counsel for Jamie Spears, is saying, listen, that other guy, he wasn't here that last time. Remember, Your Honor, when Rosengart said that we were going to hold back money from Britney if the conservatorship ended, that we were going to hold back money to pay everybody. Rosengart, that's a mischaracterization, Your Honor, of what I said. I said nothing about a reserve. Mr. Nelson is not entitled to a reserve. Mr. Weingarten's client is certainly not entitled to a reserve. I think that's something that's going to be litigated after the court has had an opportunity to review our objections and the declaration of Miss Abadi. I would remind the court that Mr. Spears, for various reasons, numerous reasons, is not only not entitled to an advance under the ex-rel Harris-Stein case, given his rampant misconduct and potential criminal misconduct, he's not entitled to a reserve under Casper Bauer. He's a man who, as far as we know, took $6 million from the estate. Mr. Rosengart, here's, rather than litigating that issue, what I really want to focus on your attention on is, obviously, no trial has been held yet. We don't know what the outcome is going to be. Everybody has their own position. What's the plan to the extent that, say, some fees are going to be allowed? Maybe none will be allowed. I don't know what the outcome is going to be. But what's the plan to have the access to those funds if funds are determined to be awarded to various counsel? So if we go to trial and at least some fees are granted to any party. How is that money going to get to the party who had fees granted? Mr. Rosengart, these are Miss Spears' monies. Her money has been controlled for 13 years. She has a right to do with her money as any adult would. I would respectfully submit, Your Honor, what she deems appropriate. If an order is entered, and we'd be extremely surprised in regard to payment of any additional fees, we will deal with it at that time. She's certainly not going to dissipate assets in order to avoid any order along those lines. I think we can deal with it when the time comes. I can tell you that we're prepared to argue Casper Bauer. We're prepared to argue Stein under those cases and under the circumstances, particularly when Mr. Spears took $6.3 million from, the court says, well, I'm not. The estate, Rosengart finishes. The court, I'm not. Mr. Rosengart, it's not appropriate. The court, hold on. Please have a seat. I'm not focusing on one party or another. I'm talking about, there's lawyers' fees, there's CAC fees, there's Mr. Spears' fees. I'm just talking about, I'm noting that there's a number of parties that potentially, after a trial, may or may not be entitled to something. If they are entitled to something, then what's the Mr. Rosengart? Then I believe that we will deal with it at that time. Miss Spears certainly has no intent to dissipate her assets, but it's a little bit counterintuitive because we have people circling 13 years after the fact trying to get more money from her estate. So I think, Your Honor, I'm sensitive to the issue. I'm familiar with the case law. I think we should deal with it at the time. The money is not going to be a Swiss bank. The money is not going to be a Swiss bank account, but it is her money, and she has the right and the ability, now that the conservatorship has been terminated, to do with it as she deems appropriate. Okay. Nelson says, yes, Your Honor, the assets of the conservatorship is being terminated. The assets of the conservatorship estate remain subject to this court's jurisdiction. And until they are distributed out of the conservatorship estate, that's exactly why Mr. Gold was asking for an order authorizing his client to do that. The court certainly has jurisdiction, and it's only appropriate to require that the conservatorship estate continue to retain sufficient assets to pay debts of the conservatorship estate, which includes outstanding claims for attorney's fees, not just for Loeb Loeb. In fact, Loeb Loeb is sort of the tail wagging the dog here because there are lots of other firms with much larger fee petitions than Loeb Loeb has, but nevertheless, we're entitled to be paid from the conservatorship estate, and the conservatorship estate needs to hold out sufficient to pay those fees until there is a determination of whether or not they should be paid. We are not. The discretion of Casper, Bauer, and Stein is a red herring. We're not asking to be paid fees now in advance. We're just saying the court should hold a reserve that continues to be subject to the court's jurisdiction to honor and pay any award that is ultimately made. So, let me explain. They want Britney, they're saying that yes, the conservatorship is over, but the court retains jurisdiction over the funds until the money is taken out of the conservatorship and transferred to Britney. So they want to make sure a reserve is kept. Mr. Gold says, thank you, Your Honor. We stand here willing to do what the court requires of us. Simply, my client is no longer going to be the conservator of the estate any longer, will not have control over the money. And so we would need to send it off to Miss Spears or her representative unless there is a contrary rule. Rosengart, that's the only order we need, Your Honor. The money is now Miss Spears. Important to note, there's a lot of things that could be incurred, even in litigation, that we don't set reserves for because we don't do that, right? Like in child support cases. If a father owes money to a mother for child support, past amounts can be garnished and withheld, but we don't hold future reserve amounts for child support if somebody comes into a lot of money. Well, but you haven't paid in the past, so we need to take it from the future. No, it doesn't work like that. By requiring Britney to set aside a reserve, you were continuing to inhibit her from access to her assets. Mr. Nelson, one of the concerns I have, this is the court, I don't know the total of all the amounts that are in dispute. I can look at each petition. I mean, I'm not adding it collectively, you know what I mean, to know precisely. Like if I added up every cost that's being requested, every fee that's being requested, and in theory, if it all got granted, what would that total be? So it's just a little difficult for me to be able to say that X amount of money, because I don't know what X amount of money is. Mr. Weingarten, may I make a suggestion, Your Honor? So this is Jamie Spears' attorney. That Mr. Sable continue to hold the proceeds until the next hearing. Counsel meet and confer and come up with that, or come up with a number to withhold, or make every effort to come up with that number, or at least advise the court what that number should be, and then we can have a discussion at that point. I'm going to spare the argument regarding all of the things that Mr. Rosengart just said, because I think the court's already quoted the law on that subject. The issue is not whether or not Ms. Spears is going to open a Swiss bank account. The issue of whether or not these fees should be paid is something that will resolve in due course. But pending resolution of that issue, there needs to be a reserve to make sure that if the court makes an award, that these funds are there in order to satisfy it. The court says, thank you, Your Honor. Mr. Rosengart, Your Honor, we don't believe any reserve is appropriate. The conservatorship has been terminated. Mr. Sable, we believe at this point, given that this conservatorship has been terminated, needs to, pursuant to his own counsel's request, turn over the funds to Ms. Spears or her representative. Mr. Ingham speaks. May I raise a procedural point here? The court. Sure. One moment. Oh. Noticed it was past 3. I think that might actually be helpful. The code section under which court-appointed counsel is paid has an entirely separate procedure with regard to payment of fees. And the code section specifically contemplates the termination of a conservatorship and specifically contemplates the possibility that the conservatorship of the estate would not have the money and that former conservatee would have the money. And so at this point, part of the determination of fees involves this court making a determination of this conservatee or former conservatee's ability to pay. The unpaid fees to Mr. Nelson and his firm, I believe, are under $100,000. I have no unpaid balance. I have no unpaid balance of fees. My fees have all been paid prior to court. My fees have all been paid prior to prior orders of this court. So we're not talking about a huge or unascertainable amount of money with regard to Mr. Nelson and his $100,000 plus cost of defense. If Mr. Rosengart is willing to represent that the former conservatee, Ms. Spears, will remain available to honor an order for payment of fees based on probate code section 1472, I'm certainly happy to accept his representation. She has very substantial resources. But I think the court, it would be helpful. Nelson, I think, is with Loeb Loeb. Loeb Loeb was retained by Mr. Ingham. But I think the court, it would be helpful for the court to raise this issue with Mr. Rosengart so we don't come back here at some point in the future with a fee order and find out that the money has all been transferred to a trust in the Bahamas. Jesus fucking Christ. You know what's funny to me? These guys keep throwing this stuff around. And it's very apparent what they would do if they had any order to pay somebody. Clearly, their money is going to the Bahamas or a Swiss bank account. Exactly. These people are telling you what they've done. Exactly. Mr. Weingarten suggested, this is Mr. Gold, that my client hold all of the remaining assets until the next hearing. That is untenable because my client is no longer the conservator of the estate. And if Ms. Spears needs money or money being transferred from those funds, he would not have such authority for that. So that proposal cannot work. So if the court were considering that, I don't know how that would work because my client can't transfer the funds. I'm running out of breathing room here, talking room. The court said, the witness. Perhaps I was missing something since I wasn't at the last hearing, but as I understand what I'm hearing today, Mr. Gold's client is still the conservator of the estate or temporary conservator of the estate, although powers are expiring shortly unless the court extends them. That may have been the probate researcher. They expire today. That's correct, Your Honor. The powers can be extended. Okay, so Rosengart says, we do have an issue. We think the appropriate way to proceed, given that the conservatorship has ended, given what Ms. Spears has been through for 13 years, is, pursuant to the suggestion made by Mr. Gold, if in fact additional fees are warranted, and there is an order to that effect, the court can issue an order. And I believe this is what happened in the Kasperbauer case. If there are insufficient funds, and I agree with Mr. Ingham's representation with regard to the amount of the funds at issue. If there is a determination that there are insufficient funds, an order can be made by the court at that time for funds to be returned or funds to be paid. There is no reason for a reserve at this point. What's interesting is we're having that same issue with Jamie Spears at this juncture. There's a concern that he has dissipated his funds, which could be used to repay Britney. And no one's asking for him to set up a reserve in anticipation of the objections to his misconduct that has happened over the last 13 years. If I may, Your Honor, Mr. Nelson says, just to respond, there is very clearly a reason, despite the fact that there are many different fee petitions pending. I think what Mr. Ingham was talking about are with respect to your fees, Mr. Nelson, given the fact that your fee request is probably the lesser of anyone's. And so that's why he brought up Loeb and Loeb's fees. But I think that, and I'm not insensitive to what everybody has to say, and I do appreciate the comments, but I think today I'm just going to need to go ahead and make the order that Mr. Gold has asked for. And I think that, Mr. Weingarten, may I be heard, Your Honor? There needs to be some representation that the resources or that the funds will be available to the extent there is an order. Without that, there is no protection whatsoever. And any order could be, and very possibly could be, meaningless. It's not the appropriate procedure for these situations. And again, the transcript is what it is, what Mr. Rosengart said at the last hearing. And he very clearly made a representation that the funds would be available to the extent there was a court order. There needs to be some way to satisfy an order to the extent that it's made. Again, which, theoretically, it would be great to have a representation that all orders have the ability to be carried out. It doesn't work like that. What Weingarten right now is fighting for his life, because if he doesn't get a reserve, and if he doesn't convince the court that Jamie Spears has some ability to get compensated from the estate for past fees that haven't yet been paid, or for his attorney's fees in representing Mr. Spears, then he has to rely on Jamie Spears paying him. Jamie Spears, who has much less in assets as Britney. Right. And again, we're not resolving the issue whether or not the fees will be ordered, but just handing them over without any protection in place for all of the various fee petitions is not the appropriate procedure to follow in this instance, Your Honor. It can't be. Mr. Rosengart. Then Mr. Weingarten can file a writ or take some form of action. I don't appreciate that he interrupted the court. Respectfully, Maddie boy, you did that quite a bit earlier. I don't think the court appreciates it. We stand by Mr. Gold's suggestion. If, in fact, an order is issued, whenever it's issued, requiring Miss Spears to pay additional fees or have additional fees come from her estate, then we can engage in some sort of motion practice to the extent necessary. The court. But, Rosengart, no reserve is necessary here. If there's an order, or if there's an order fine, then, Your Honor, that additional fees are appropriate, then an order can be entered, I suppose. And this is what happened in Kasperbauer, ordering Miss Spears to pay those funds. A reserve is simply not appropriate under these circumstances. And for Mr. Weingarten to interrupt the court, lecture the court when his client has $6 million is inappropriate, Your Honor. Mr. Weingarten, may I respond, Your Honor? The court, briefly, because I'm going to make a suggestion. Okay, go ahead. I can't imagine. I know a lot of people have to take issue with this court and this judge, but I can't fucking imagine. We've been going for, what, an hour and a half? And I've been, like, running through it. So this likely took longer. I'll wait for the court's suggestion, Your Honor. Thank you. What I want to do, the court says, is I want to take about a 15-minute break, maybe 20 to 3:15. I want everybody to look at the code and give me some authority for your position about no reserve versus holding some funds back. And then I'm happy to take a look at the code and I'll let you know. Mr. Weingarten, can I make a suggestion instead of rushing through it in 15 minutes? Can we brief the subject quickly? We can come back very quickly, but I think that's going to provide more meaningful opportunity for everyone to be heard on this issue, as opposed to just doing it without adequate resources and on the phone. and have everybody make a snap judgment and Your Honor be forced into making a snap judgment? Bring us back in a week. Court, okay, let's take a break till 3:15 and let me think about that, okay? All right, then we'll come back. All right, then we come back. Oh, court. Okay, I think I've got everybody else back up on the screen. I didn't anticipate the break was going to lead to a power outage. Anyway, we're back. Interesting. I have to tell you, during the break, I did think about the issue that you were discussing. I'm not going to order a reserve. But you just asked us to go look at the code. You couldn't have, told us that? I got powder on my forehead. I feel like the sun's shining on it. Mr. Weingarten, Your Honor, may I? Sure. I just want to read from the transcript from the last hearing. Okay. I think we'll clarify things. I'm reading starting at page 18, line 21. This is me talking initially. So as long as there's a representation that money will be available to the extent that it's ordered by the court to pay the fees, that's fine. Again, I'm just concerned, and I think it's what I'm hearing is very carefully worded, and I haven't heard an explicit assurance that to the extent, for example, Miss Spears, Britney's mother, has filed a petition for fees. They have a right to have that petition heard, and if that petition is granted in full or in part, to have those fees paid. And I just want to make sure that the money will be available to the extent that an order is entered by the court approving any fees. If counsel for the temporary conservator and for Miss Spears can provide that assurance, then we have no issue. Mr. Rosengart responds, Your Honor, we have no issue. The court then says, okay, so you can provide that assurance to counsel. Mr. Rosengart says yes. So an express representation by counsel at the last hearing that the money would be available to pay to the extent that the fees are awarded, contrary to what counsel is trying to argue today and what he said about what he said at the last hearing. Importantly, that conversation, that hearing transcript did not say that a reserve would be held. It said that any orders for fees would be paid. Additionally, counsel's argued Kasperbauer. What Kasperbauer actually held was that based on counsel's representations that money to pay the fees would be maintained and available in the event that there was a fee award, the court in that instance said that the reserve was not necessary. So there either needs to be a reserve, and the reserve can be held in the Greenberg-Traurig trust account if appropriate. So Britney Spears attorney trust account. Or counsel needs to make representation, stand by the representation that he has already made to this court that to the extent that fees are awarded, that the award will be honored by Miss Spears. And only under Kasperbauer and based on counsel's own representation to this court, only under those circumstances is it appropriate for a reserve not to exist. Rosengart says, Your Honor, very briefly, I've consulted with counsel. And then Weingarten says, Your Honor, if I may. Rosengart just doesn't fucking care and continues. Excuse me, this is the second time that counsel has interrupted the court, which did its own research. We've consulted internally. The last thing Miss Spears should have to do is endure a further round of briefing, a further round of expense, which, by the way, he's going to come back and ask his fees to be paid on this issue. Interesting. Rosengart, Britney's attorney, is saying, Jamie Spears' attorney is asking not to have the issue resolved right now, but to leave, brief it, come back, for which he is going to bill Britney at a later time, and he's arguing a reserve should be held to pay for that research. Does that make sense? Oh, goodness gracious. We see this as very straightforward. They could make whatever fee application they want. They've done so. We will put in our objections. The conservatorship has been terminated. If they win fees and there's a final judgment in that regard, then presumably will be paid or they can enforce it. There's no reason to overcomplicate the issue. The conservatorship's over. Mr. Weingarten would like strings attached. He'd like it to continue. If he obtains or any counsel obtains the final order, they can enforce it, which is true, just as with any other court order. There's no intent to dissipate funds. This conversation really should be academic. The court twice indicated what the court's ruling was going to be. Mr. Weingarten presumptuously interrupted the court twice and presumes to dictate what I or the court have to do. We respectfully submit the court should stand by its ruling, which makes sense. It's appropriate. It's legally appropriate. We see no authority for the proposition that a reserve is appropriate under these circumstances and not order a reserve. The court, okay, thank you, Your Honor, Mr. Nelson. David Nelson speaking. Mr. Rosengart asked for authority. I'd like to provide some. Probate Code Section 2630 says upon the termination of a conservatorship does not cause the court to lose jurisdiction of the proceeding for the purpose of settling the accounts. That is exactly what we're asking the court to do, to retain jurisdiction over the conservatorship assets, just sufficient assets to enforce any judgment or award fees. Your Honor, Mr. Nelson, the court, Mr. Nelson's still talking. Mr. Nelson's been paid. Thought he was finished. Very briefly, Mr. Nelson's been very active during this hearing. He's been paid 80% of his fees. He and his firm are not being prejudiced in any way without a reserve. He's effectively attacking his own former client, Britney Spears, claiming she's going to dissipate assets. That's number one. Number two, the authority that Mr. Nelson purported to cite is not authority that supports the proposition for reserve. He's citing the basic statute for the proposition that the court has jurisdiction. We don't disagree with that. So if they obtain a court order, they can come back to the court, which may or may not issue such an order, and enforce it. It doesn't need to be more complicated than that, Your Honor. The court, I think that Mr. Nelson has correctly cited what the situation is in a conservatorship, even when it's terminated. There's winding up, and that's what we're talking about. That's what Rosengart interrupts the court. Agreed, but not in regards in the necessity under these facts, Your Honor, of a reserve, as the court has already ruled. The court, that doesn't change what I'm thinking. Mr. Rosengart, understood. Mr. Weingarten, Jesus Christ, shut the fuck up. May I make 2 points, Your Honor? Just 2? That's it. Mr. Weingarten, just 2. Number 1, again, counsel represented to the court at the last hearing that this was taken care of, and based in reliance on that representation, everyone else acted accordingly. The representation's already been made. Counsel is now denying that the representation they made on the record was actually made when I just read you the transcript where it was made. That's number 1. Number 2. Here's where y'all are going to get real amped up. Let's remember, because counsel has made this argument that the assets won't be dissipated. She won't fly off to Switzerland. Let's remember why this conservatorship existed in the first place. Because Miss Spears was irresponsible with, among other things, her money. Mr. Rosengart says, Your Honor, this is beyond the scope and highly inappropriate. The court, please, yes, let's not go there. Mr. Weingarten, well, but he should stop, Your Honor, Mr. Rosengart says. The court, Mr. Rosengart, please. Mr. Weingarten, Your Honor, it's relevant to the issue of whether or not the money would be available to the extent that you make her deal with it. It's directly relevant. Mr. Rosengart, Your Honor, the conservatorship is over. Mr. Weingarten, counsel, I didn't interrupt you. The court, Mr. Rosengart, please. I've asked, let's not go down that road, okay? Anything else? No, Your Honor, from Mr. Rosengart. The court, okay, so I'm not going to order a reserve. I think there's enough statutory protections in place when the conservatorship has been terminated, and there's still pending petitions to, take care of that. So circling back to you, Mr. Gold, I will make the order that you requested. 2 other fee petitions, Miss Montgomery and Miss Wright, I made an allowance on those fees. Yada, yada, yada. Not a lot going on there. Try to see if Rosengart and Weingarten get into it again. Trying to see. Court, thank you. Just for the record, it was filed. Bronshteyn. Your Honor, under Section 1043, we are going to submit objections. My hope is to continue to speak with Mr. Jones and Mr. Bronshteyn and potentially work it out, but at this point, we cannot agree. Who does Let's see. Okay, Mr. Bronshteyn, that's your fee petition. No objections have been filed as of yet, so I want to hear from you, and then I'll hear from counsel for Miss Spears. Mr. Bronshteyn, Thank you, Your Honor. As the court's aware, since our involvement on behalf of Lynn Spears in this case came back in May. Hey, dude. Lynn Spears walked into this courtroom at the request of Britney Spears, with Britney Spears. There was a lot of bravest testimony under court seal that Britney Spears provided. We've been instrumentally involved from 2019 until today to deal with what was a very difficult conservatorship. What Britney Spears identified as a very deliberate process that interfered with her liberties and her self-esteem and her ability to function as an individual in our society. Good point, Steph. Why does she need counsel to come in and support her daughter? Through negotiations with court-appointed counsel, Mr. Ingham, with mediation sessions, so important. Prior to all of this popping off, prior to Britney coming in, mediations were set. The purpose of a mediation is to get everybody to come together. So that means there was a significant rift with counsel and parties such that they needed mediation. Mediations are generally confidential in California. The contents of the mediation are not laid out for the public. But I can speculate that likely what was being done is Jamie's, in that same vein, dangling freedom, just pay off. Just pay off my fee petitions, my attorneys, and give me an amount of money and waive any and all liability I may have, and I'll let you go. I'll let you fly, little birdie. Just pay me off. Pay me off. Release me from liability, let me go. That's what I anticipate was likely the subject of that. I'm sure it was much more complicated, many more people involved, many more arguments made than that, but generally speaking, that's what I speculate possibly was happening. We've been instrumentally involved. What Britney Spears identified as through negotiations with court-appointed counsel, with mediation sessions, and with constant pushing by my office and Joan Swanson, we were able to ultimately get private independent counsel, which was Britney Spears' goal, which was our goal to turn this conservatorship around. And though this matter has been pending for over 13 years, we were able to finally end the conservatorship, and here we are today. There's been a tremendous amount of value added to Ms. Spears' perspective. It was with no fee awards historically, no fee awards requested historically, which, I mean, great. Except that you're coming in after the fact and saying, pay me for all that work. We came in, did the heavy lifting, got things done, and after the fact, we are seeking a reasonable award based on the value out of it. And given the totality of, I think it's like $660,000, something crazy. And given the totality of circumstances through the lens of equity, we feel it's completely appropriate. And it was done as expeditiously as possible and at a very reasonable cost, given, again, the notoriety and attention to detail. And as much litigation counsel as we had from the Holland and Knight firm, to whose fee petition we objected to the Loeb Loeb firm, to everyone else, we were able to get independent counsel without a trial, without an evaluation that Britney Spears did not want, and we were able to help support the termination of the conservatorship. So for the sake of brevity, given how long this hearing has gone forward, we think the fee amount is appropriate. And again, no objections have been filed. The petition was filed on November 1, 2020. Mr. Rosengart says, we are going to submit objections. My hope is to continue to speak with Mr. Jones and Mr. Bronshteyn and potentially work it out. But at this point, we cannot agree. And we note that what was set forth in the probate attorney notes, and that's all I have to say presently on that point. So Rosengart is at least holding out a little bit of hope that he could work it out with Lynn's attorneys. Court says, okay, it is the first hearing. He does have a right to file objections. Mr. Bronshteyn says, I'm fully aware of that. And Mr. Rosengart reached out this afternoon, suggested we speak informally, try to resolve things. My only request for the court is, if you're inclined to give Mr. Rosengart and his firm the time to file objections, that we try to keep this on a shorter time. And more than that, separate this potential hearing from some of the other more litigious hearings. Our circumstances will involve no discovery, will involve no disputes. We objected to the Holland Knight Jamie Spears accounting. We had nothing to do with preparing the accounting. So I think it would be appropriate to have a separation of these hearings. He doesn't want to be lumped in. He doesn't want he and his client to be lumped in with Jamie Spears and all the other litigation. I think our petition is very straightforward. Hopefully it will reach a resolution in any event, but I wouldn't want to tie up your calendar and help generate more delay in dealing with our petition. Sure, that's the reason. Hello. The court. Okay, so let me ask the two of you about how long do you think it will take to, you might need to meet and confer and then get this back. Do it in person, by phone, or Zoom. Our offices are blocks apart. I can't see unless either one of us has some heavy litigation coming up why we can't try to meet and confer in 2 weeks and then give until mid-February to file objections. If we could say, this is Rosengart, meet and confer, file objections by February 28th. Come back and see me March 16th. Have to be the 16th for me because I'm out the second week in March. Okay. Available 16th. So what I'll do, I'll put this petition at 50. Sophia, can you let Buster out, please? Okay. And on the other petition, so they're going to come back on March 16th with objections to be filed by February 28th, I think is what we said. All right. Okay, so what I'll do, I'll put the petition at 5012 over to March 16th, and on the other petitions for which there are going to be, well, there's been objections filed. Counsel's indicated there's going to be a response filed to the objections that were recently filed. I know there's going to be ongoing discovery in many of these petitions. I'm looking at maybe having you come back and see me in June on these. Does that give you enough time to get your discovery going, or do you need more time than that? Mr. Weingarten, much sooner than that, please, Your Honor. The court. Well, I can't get you back in here before then, so it would have to be sometime in June. Mr. Rosengart, it's also not practical, Your Honor. Consistent with the court's calendar, I understand we can come back in June, but we have a lot of discovery that we have to go through, so June is fine with us. I was actually going to suggest July or August, but if it needs to be June, the court, well, those are open too. I mean, I can do July or August. Mr. Rosengart, I think mid-July, the court. I really want people to be realistic about, Mr. Rosengart says we have to be, what has to be done in the likelihood that you'll be finished by the time you come back and see me. Because since there is going to be a hearing and all your discovery has to be complete before I can send you to Department 3, and then I have to know that the likelihood is greater rather than less, that when I have you come back and see me, all the discovery is going to be complete. Exactly, Your Honor, and I'd rather not do this piecemeal. Mr. Weingarten, Your Honor, you offered June and now we're pushing it another month? I would suggest the week of June 6th. Mr. Rosengart, that doesn't work for us. Mr. Weingarten, you haven't even checked, counsel. We're available July 17th, or the week after the 17th, the week of the 24th, and in fact, any day of the week, the 24th, the court. How about July 20th, Mr. Rosengart? Would the 27th work, Your Honor? Yes, we could do that too. Okay, Your Honor. So, Weingarten is like the baby in the corner crying, but I wanted it earlier. But no, you said June. Why are you giving July? What, the last week of July? Man, this isn't fair. Anyway. I'm going to be on the East Coast on the 20th. I'm available anytime during the first or second week of August. I'm available on the 20th. I'm not available on the 27th, Mr. Weingarten said. First or second week of August, except for August 4th, Mr. Weingarten. How about July 13th, Your Honor? Court. I was just going to ask that. How about July 13th? I'm on the East Coast July 13th also, Your Honor. July 6th? We're moving in the wrong direction because, Your Honor, we're going to need to complete discovery before this hearing. And I think the last thing anybody wants is for us to come back and then have it kicked. How about August 3rd? Your Honor, I will move my commitment on the 27th or have someone else cover for me so we don't have to delay this any further. I want the 27th. The court. So you're saying you could have somebody else available to cover for you on July 27th? I will either, the other commitment I have, I will either make arrangements or rearrange that or have someone else cover it so I can be here on the 27th. Court. Okay. How's July 27th? I think you said that works for you. Works for us. And then everybody else agrees. So we'll reserve July 27th at 1:30, and that's going to be for calendar matters. They're not in any particular order. I'm sorry about that, Anthony, because I separated these matters. We're looking for an update on counsel on where you are with discovery, if discovery is complete, or if there are some issues that still need to be resolved in discovery, and that will guide me about getting you over to Department 3 to get a trial date. We intend to file a motion to unseal. I'd like that to be set for February 17th. We have to actually look at our motion calendar to see whether or not we've got motions on calendar or whether or not we're doing something else in the afternoon. Should I just talk to Your Honor's clerk? Well, Your Honor, we have an issue with that date. First, we're going to need, this is a major motion. We believe it's a very regrettable motion because remember, the idea that you're going to unseal all of Britney Spears' personal private information, that's a huge issue. But if he insists on moving forward, we're going to need ample time, Your Honor, to be in a position to prepare ourselves. So with regard to this motion, we believe that a June or July date would be much more appropriate. Your Honor, counsel hasn't even seen the motion, this is Weingarten, or knows what it's going to say. I would suggest we set the hearing date for the first available opportunity. To the extent counsel feels that they need more time and that good cause exists to have more time, then I'm happy to meet and confer. But if that's not successful, then he's always available to come in ex parte and ask for more time. But delaying this is inappropriate for the reasons that we set forth in the motion, but I'm not asking the court to adjudicate the motion right now, just have it heard. Mr. Rosengart, Your Honor, I stand by what I said. We believe it's putting aside the highly inappropriate motion. I cannot express how absolutely fucking disgusting it is that he's filing this motion. But number two, I do not understand an attorney that thinks it is a good idea for his client to ask the court to unseal the 13 years of conservatorships that he's presided over as conservator in the same time frame that he's seeking to show himself as a responsible fiduciary to Britney. In other words, it's bananas to me that his attorney is saying he's a great guy. He's going to have to defend himself against all of these allegations that are being made, these false accusations that aren't true. Also, he would like to unseal all of the conservatee's personal private information. Like, if I'm Rosengart, I almost say, like, fucking set it. Set it. Because I'm going to use that motion. I'm going to attach that as an exhibit, and all the statements that you're going to make and all of the evidence that you're going to try to enter, all of that, I'll just attach that to my motion to prove that your client is a fucking douchebag. Anyway. They're moving to unseal years of records, exposing our client's privacy issues, having already invaded her privacy over the past decade. This is not something that's urgent. There's only one reason for it, and that's so Miss Spears can try to defend himself. Mr. Spears can try to defend himself at the expense of his daughter. There's no rush here, Your Honor. The court. So, counsel, I have to look at about 3 or 4 calendars in order to figure out motion dates. I've got to look at it. Other housekeeping issue, Your Honor, Weingarten saying this, is that I don't know why. I presume it's my inadvertence, but the objections that were filed by Miss Spears yesterday, or whenever they were filed that we all received yesterday, were unverified. So that needs to be rectified. As of right now, they are not valid objections, but because they have not been verified. That's part of the whole probate process with the probate attorney, yada, yada, yada. Just one issue with regard to the date concerning his motion to seal. We're very concerned about communications with the clerk, which would put us back in the same position that I'm concerned we're in right now with the February date. I'd like to know from the court that motion won't be set at least anytime before April or May. Regardless, we're going to need time to prepare. We're entitled to discovery on the motion, and I'm very concerned about the clerk, through no fault of his own or Your Honor's, setting a date that's premature for the motion. There's absolutely no urgency. We hope that Mr. Spears and his counsel will come to their senses and rethink it. But we'd like at least understanding that the court needs to check the court's calendar and understanding that won't happen at least until, I would say, April, mid-April, so we have sufficient time to prepare our responses. The likelihood that you can get a February date is probably nil. I don't even know about March because March is getting pretty filled up last time I looked. So it may be a little later date than you're thinking about. Rosengart says, we at least like, just for the sake of clarity, Your Honor, a ruling that it doesn't occur before, understanding that dates may not be available. Strange things happen sometimes and things open up. That whatever the hearing date is, it is not before April 15th. We're not prejudicing anything right now. He hasn't seen the motion. Yada, yada, yada. They keep going with these housekeeping issues. I'm trying to wrap it up, but it keeps going. There's just one housekeeping issue, Rosengart says. There was a calendaring issue in regard to a motion that the court alluded to earlier concerning TriStar's motion to quash. We'd like to discuss a date to having that on calendar. It's off calendar and after Thumper. Bella, you done? Bella? Thank you. Appreciate your cooperation. It's off calendar, and after consulting with counsel for TriStar this morning, we're ready to put it back on calendar. May ultimately not be necessary, but we need a date on calendar, and I understand counsel for TriStar has his calendar available, so they start setting that calendar date. I'm gonna move through. One last clerical matter, Weingarten says, Jesus Christ. Where did it go? One last clerical matter. This is Samuel Ingham. I would echo the request for being served. Another housekeeping issue, related housekeeping problem. For some reason, the clerk's office has decided I am no longer a party to this case, so I no longer have access to the case file through the portal, and my cost account is not unlimited, and it's a problem for me to have to pay for every copy of everything that doesn't get served on me. I am not sure procedurally. Maybe I should work it through your clerk, Your Honor. I don't know exactly what the answer is, Mr. Ingham, but I can tell you the source of the issue is that once CAC has been discharged, then that closes the portal for them. But the issue here is a little bit different in the sense that there is ongoing litigation. So even though he's been discharged, he still would need access. Okay. Mr. Nelson, I apologize for interrupting. They're going to take a look at this particular issue. I understand. Housekeeping issue, I believe the court was going to give us file by date for objections. That was going to be my housekeeping issue. File by June 27th. So objections by June 27th, hearing on July 27th. Weingarten. Sorry to interrupt, but just because we're all trailing here together now, as long as that's not a reason for yet another delay, the idea that discovery would be concluded by the time we come back at the end of July. The aspirational goal here is to have discovery completed by then and to move over to long cause and trial setting. I want to make sure that giving that much additional time to file objections, it isn't going to cause any further delay. Mr. Rosengart, I don't anticipate it, but I'm concerned about July 27th in terms of discovery. We haven't even seen their discovery responses. Fine. Usually there's a discovery cutoff, and she says she's not setting a cutoff where so interesting because probate court is so different. But in general civil cases, discovery cutoff is 45 days prior to the trial. So you would need to have served your final discovery 45, 60. I usually set mine like 90 days before that because I need to serve discovery, get them back, be able to meet and confer, and file a motion to compel. So it's really important that they make sure that there's no discovery cutoff, because if there is, then you have to back end into your discovery. All right. Email service is agreed. I'm trying to see if there's anything else. Nope, that's it. All right. Can you look and pose for your YouTube thumbnail, please? Heather deserves an award for this marathon reading. It was impeccable. I appreciate that. Thank you very much. I was talking to Steph and I was like, there's a bunch of things I want to do as far as TikTok goes. And the Jen Shaw stuff is popping off. The Erica Jane's got another lawsuit filed against her. Britney Spears stuff is ongoing. Now there's a Real Housewife of Orange County who's got pending litigation against her and other allegations. What else was there? I had a bunch of thoughts in my head just this week because of the difficulty of this week. Last week was a hard week. This week was tough because I started it with COVID in my family. And there was stuff that I just wanted to make TikToks on about, like, being a mom is fucking hard right now. It's just hard. And, like, I don't know what the answer is, but, like, just give yourself grace. Like, I wanted to do all kinds of stuff. And I kept telling Steph, like, I want to do something. But I have, like, decision paralysis. Like, I just can't do. She's like, just do something. What do you want to do? And I was like, Britney Spears is awesome. I love doing that stuff. If Britney ever writes a book, you must read it to us on your podcast, like an audiobook. Done. As long as she gave permission. My thoughts on Kanye. I think it is... I'm not immune to this. But we have all kind of sat back and watched this play out like a reality TV show. And it's really important that we recognize that there are 4 young children, an ex-wife who went through significant trauma in a robbery where her life was threatened, and a man with mental illness involved. And I know that's probably not, it's speculation, legal analysis of it all. I think if we're talking about the legal part, I think he's setting himself up for a world of hurt in court. But I think human to human, this is just devastating for the kids and for someone who's experienced a level of trauma that she's experienced. You don't have to like him to appreciate the fact that she's got shit going on, that this makes it very difficult to deal with, especially when you've got Kanye making sure that all of this, everything's public. It just sucks. It sucks. Feel like K-Fed is going to make Britney seem bad too. Maybe. I don't know. Yeah, I'm not a Kardashian fan, and what he is doing is so wrong. Yeah. Tagging her boyfriend and stuff, or adding him. I mean, just the whole threatening him on a music track. The whole thing just sucks. Do you think he makes it public to make sure they don't control his narrative? Maybe, but I don't think it's just his narrative that's getting publicized. Like, if it was just like, here's my side, I didn't get to go to my kid's birthday party. Done. But instead it's, I want my wife back. I'm going to fuck up her boyfriend. Fuck this dude. You're never meeting my kid. Like, it's just so much more than that. It's, if you imagined like a close friend of yours posting publicly about their divorce from their wife or husband, and fuck her, and she won't let me see the kids, and fuck her and her boyfriend, and fuck this and that. You'd think that person was doing a disservice to their legal case, abusive to their ex, putting out a bunch of information publicly about their kids that would hurt them in the future. But because it's Kanye, it's like, oh, it's it's an episode, but it's going to produce great music. I think we could do without the music. If this is the cost. He doesn't seem to want her to be able to get remarried based on the reports and demands. Interesting. Oh, he doesn't have a girlfriend anymore. I kept hearing about the Uncut Gems, and then I opened up Instagram today and I hadn't seen it. And I watched it. Uncut Gems? So now that's going to be in my head. Of course. He's unhinged, though. I'd be scared to leave my kids with him if he was a father. 100%. Uncut Gems? What can we expect next on Britney's case? So we've got a motion to quash pending. I'll look and see when the dates are set and do a quick video on it. Maybe tomorrow, maybe Monday. And other than that, what I can expect is that probably Jamie Spears is not going to be forthcoming in discovery, and there's probably going to be a motion to compel. Not the same, but like Woody Allen, the person is shit, the art's not even that great. Interesting. In your opinion, what's one thing that's really concerning with this case or stands out in the Britney Spears case? The fact that attorneys representing Jamie Spears fail to acknowledge and adequately articulate Jamie's position. Like, they have zero understanding of how bad they look, legally and from the public. It is absolutely insane to me that in July to September of last year, when Britney was asking to get out and the motion was filed, that the opposition of his removal went from "I'm fucking stellar #1 dad" to "I'm stepping down, I'll let you know when later" to "we just need to terminate the conservatorship." It's so clearly personal. There's not even a hint of protection of Britney. Not even a hint. And he has a fiduciary duty to her, especially at that point. Same here. Different attorney, same fucking circumstance. We'd like to unseal the entire case. But don't you have like a pending situation where your client is it's being alleged that your client did not abide by his fiduciary duties and protect Britney and handle her assets well and all of that? Yeah, but like, we want the public to know. Like, the public doesn't have, we have a public interest in this case. Courts are open for a reason, but the public does not have a right to know the information in this case. There's no public right in this. This isn't a public interest case in the sense that like we need to know all aspects of Britney Spears' prior care. We need to, on a public level, litigate her ability to function as a human. That is not accurate. Yes, there is a public interest in the case, entertainment-wise, but not on a legal basis. There's zero need to have the whole thing unsealed. And to make these legal arguments where the argument so departs from his duty as a fiduciary, and you are unable to see that. Like, you're the villain publicly, but you're making bad legal calls in the courtroom, and you're giving ammunition to the other party. Gaslighting. Yeah. So that's my thoughts. 4 p.m. Jeez. I'm going to go hang out with the family. Hopefully I am COVID free, because that's the way to be. And hopefully my daughter kicks it quick. And we'll have a good weekend together regardless, because she's likely not contagious anymore. This will be on YouTube. Yeah, that's why Steph was making me pose for a thumbnail earlier. Thanks, guys. Oh, thank you. All right, have an amazing weekend. If there is one thing we all collectively deserve, it's a fucking amazing weekend. All of us. All of us.